Let me say how grateful I am to be with you, and I'm thankful for the Law Foundation and the Faculty of Law here for the invitation. Also grateful to be with Jacinta and other friends that are here, and Carwin for your organization and watchfulness over me while I'm here. I've really appreciated that. Today I want to talk about this idea of originalism and the law. By so doing, I want to try to decenter law and history and invite attention to our complicity and our agency in working with these disciplines and think about some of the implications that flow from that kind of work. As is one of the themes that's developed here over the morning, there's this quote from an author that I really appreciate, which is to beware the danger of the single story. And I've seen that caution in all of the talks that have been part of our discussion today. The contribution that I want to make to this is to have us think about origin stories and the law, and maybe make some connections to how law attempts to be or has the effect of being metaphysical in the way that it frames questions and it mediates relationships with and amongst peoples. This idea of law as metaphysics grapples with the large questions of religion. Where did we come from? We have this idea that we're always searching for in terms of the law's origin. And so much of legal interpretation tries to pay attention to those questions. But we also engage in ideas as to why are we here? The purpose of interpretations of a statute or a constitution or an historic common law or customary interaction has us engage in some of these kinds of inquiries. Also the idea of where are we going? These big questions of the great religions of the world are also the questions of law. The idea that law has some kind of prescriptive power that would take us into a future state and bind us in that future state are an element of our discipline. This idea of law as metaphysics, of course, pays strong attention to the idea of authority. And in authority, as terms, law's power seems to be growing in relationship to other systems of authority. So in our increasingly secular society, we ask, who are our leaders? To whom do we defer in terms of understanding authority and properly interpreting how we should relate to one another? Again, the questions of why are we here? Where did we come from? Where are we going? In the past, the people that we would have looked to for deference are priests and shamans, elders, ceremonial leaders, servants. There would be a whole cadre of hierarchical relationships that would give us some questions and some guidance around authority if they fulfilled those roles. I want to put to you that judges, professors, historians, lawyers, and clerks, and others increasingly come to fill this role in a society that's no longer paying attention to those other figures in terms of deference in figuring out these larger questions of law's source, its purpose, and where we're going. Or in some ways, we calibrate our purposes of life based on what we're often given in these by these people. We also can think about what are our sacred texts. So to what do we defer? And we know in other times, and this is still an ongoing thing, the older ways are not eclipsed. They continue to interact and mingle with another set of laws, contemporary metaphysics. But we would look to Scripture, we would look to tradition, and we would find from those ways of reciting, why we're, where do we come from, why we're here, where we're going, answers to those questions from those particular sources. Now, we tend to look to constitutions and treaties and statutes, and we take I would say both approximate, that is in proximity to time, calibrations to how we should plan our affairs in the world, but increasingly in the absence of God or religion or other systems of authority. This leads us to some more ultimate types of conclusions, even though we might not explicitly theorize them as such. Implicitly, we live in some ways in a system that's colored by a metaphysics that's deeply inside us, that guides our sense of ourself and the universe by these kinds of documents, by these kinds of texts. And so there's a kind of deference that's often given there. I want to talk about interpreting the canon in light of what just happened yesterday as Justice Antonin Scalia passed away. When I was teaching in the United States, I became quite aware of a pattern of reasoning around authority and legal metaphysics as I was teaching Justice Scalia's cases. As you know, he was kind of the high priest of an origin story that put a sacred text, that is the Constitution, in its original form in the heart of what is regarded as the way the United States society would organize itself. And so he, in frequent occasions, referred to originalism. Here's one of his quotes from 2005. "I'm one of a small number of judges, a small number of anybody, judges, professors, lawyers, who are known as originalists. Our manner of interpreting the Constitution is to begin with the text and to give that text the meaning that it bore when it was adopted by the people." And I have to say, much of the discussion that we were having this morning around the Treaty of Waitangi had some elements of that involved in it. What was the meaning of the text at the time that it was passed, and what, therefore, legal meaning might we draw or not today, given the talk you gave as well. He says, although it is a minority view now, the reality is that not very long ago, originalism was orthodoxy. I would say it's orthodoxy in the United States, even at the present. Everybody at least purported to be an originalist. If you go back and read the commentaries on the Constitution by Joseph Story, a former Supreme Court judge, he didn't think the Constitution evolved or changed. He said it means and will always mean what it meant when it was adopted. This idea of interpreting the Constitution is both looking to the meaning that the drafters had in their mind at the time the document was framed in 1787, and then the contemporaneous debates as the Constitution was ratified in the various jurisdictions as it was being accepted. This interpretation of a canon, looking to a precise moment and then drawing meaning from that moment, I think, again, has increasingly come to take on an authoritative force in our increasingly secularizing society. We can then put that origin story aside other origin stories, look at comparative canons. And I think something similar goes on in the United States to what you might often see in Genesis. This idea that God spoke and created the world in a certain way, and from that creation was set in motion a certain way to be, a way to live that's patterned on that thus saith God idea, looking to those original moments for our formation and our guidance. We know in the Quran there's various interpretations around origin stories, and then there's a dispute, as there is in Genesis, as to whether or not you take the initial or original story as literal, as God's word, or whether or not you can innovate on that, whether an individual has the right to receive revelation or a priest has a right to be able to give you guidance in relationship to what that interpretation is, or in the Quranic sense, you have the Sunni with one view of how you view that tradition, and the Shia with another view, but often disputing around the origins. What did the Prophet mean when these words were given, and how are we meant to carry those words of the Prophet into the present? So this isn't something that just lawyers do in our metaphysics, but I purposely put this aside beside the legal conversation, to have us realize that to some of the same things that people celebrate in these religions, that we can celebrate in our own legal traditions, can also become problematic. The critiques that we see as we look at religion around the world might also be critiques that we can see and perhaps be more available to us when we realize the analogies that might be there, as of course also paying attention to the distinctions and the differences. Evolution is an incredible origin story that people, yes, debate about and fight over, and there's not 100% agreement on the various branches of evolution and the way genetics are tied together. But nevertheless, there's a popular understanding about evolution that you quite often see cited, and people make decisions and they defer to and they calibrate choice on the basis of a worldview. You know, why are we here? Where did we come from and where are we going, given how evolution is often theorized. My own people, the Anishinaabe of the Great Lakes in central Canada, talk about the world being created on the back of a turtle. We have a diver's story, and in this diver's story talks about the flood and the earth being brought up from the ocean bottom and put on the back of the turtle, and our trickster dancing around on the back of the turtle, and seeds growing and plants growing from the things that were brought up from the bottom of the earth by the divers. And a lot of Anishinaabe and other indigenous peoples in North America will talk about North America as being Turtle Island. And they will calibrate, again, present-day obligations, future-oriented purposes, and reasons for why we're here to that kind of story. And that story has a metaphysical element, but it also has legal elements for Anishinaabe, other North American people, as we see in that story's patterns for living, how we should be guiding our life. The story here, of course, of Maui, bringing up from the depths the island and the trickster role of Maui. Think about wakas and arriving on this shore, and the creation stories that are told about that, and the whakapapa and the genealogies that go back in that way have a resonance to these other kinds of canon and are part of the way, again, we try to organize our world. Think about what our obligations are to one another, to the animals, the plants, the waters, the skies, the rivers, and they set in motion in an interpretive way how we might relate to one another and to ourselves. And then, of course, the stories of Captain Cook and the conglomeration of understandings that are around the ideas of sailing out and discovering and conquering, and through adverse possession and cession and etc., sets in place legal narratives, metaphysical narratives. People imagine themselves and their place in the world being based on some heroic story of these voyages, or some story that they need to make atonement for because of the way we've interpreted the collision of cultures and ideas and peoples that flow from the power that's a part of our metaphysics. So I started to sketch this out a little bit. What is or are New Zealand Aotearoa's origin story or stories? Where, the question again, where did we come from? Right, this one idea, this is the Lex Loki lecture in some, or Maori lecture in some way. The transplanted British constitutionalism. Where did we come from? We came from Britain. And we did so through these ideas of discovery, conquest, adverse possession, and reception. And each one of those stories being like a gospel. You know, the gospel instead of Mark, Matthew, Luke, and John, the gospel of discovery, the gospel of conquest, adverse possession, reception. Sometimes they're harmonized, sometimes they're wildly at variance with one another, and you need interpreters to be able to figure out the metaphysics of what has been set in motion as this story has come to these shores. Of course, we have Tikanga Maori and its sensibilities around how our genesis, our origin, our law should be formed through that. I always have been attracted to the Ranganui and Papatakanku story about bringing light into the world as people pushed apart the earth father and the sky mother, and again Maui is part of that. I also find when I get received on marae, maybe you experience this differently, but being Indigenous from North America, I always hear an origin story recounting of a place and a relationship that is, where did we come from? Why are we here? Where are we going? And there's something from that these, in other words, these creation stories aren't just told once and left, they're continually retold. The once upon a time is also this time, and there's a way of renewing those sensibilities through this metaphysics. We come from a social contract. This idea of the Treaty of Waitangi. My own great-great-grandfather signed a treaty dealing with 1.5 million acres of land in Ontario. He put his otter on the document in an agreement to be able to share the land with those that subsequently arrived. We often say in Ontario, at least in my territory, that we are all treaty people. That those who signed the treaty on behalf of the First Nations are treaty people, but those who receive the benefits and trace those benefits to the Crown also are treaty people. There's something of social contract that gets added into that sort of origin story. And that story, there might be attention given to colonialism, reparation, and participation that could be guiding our lights. So again, as some of the influences of other metaphysics fade in our world, these kinds of metaphysics seem to come to the surface, and they replicate modes of reasoning, and we have ourselves participating in patterns. We think we may be living in a post-religious, a postmodern world, but in fact there's something that's carried along with this. There's even this sensibility, if you go to postmodernism or relativism, that, well, we really can't identify any of these as true origins, the British constitutional transplant, the tikanga Māori, the social contract, because they intermingle with one another in so many ways. And so we ascribe a mystical origin to this. That is, law is, or origin is everywhere and nowhere. It cannot be pinpointed. It cannot be described. It's like a Nicene Creed in some sense. And law, like the Nicene Creed, can struggle with trying to identify the there in terms of who the figure or the authority is that is requiring deference in the way that we interact, again, with one another and the world around us. That's one origin story. Of course, in the paper is another kind of origin story which goes on in Canada. I make the argument that history and the interpretation is a necessary part of the law, that you're always needing to pay attention to roots. But what's happened in Canada, at least in contrast to the United States, is in the United States you just always pay attention to the roots. You can't seem to grow any tree that's not planted in it with a seed in the constitutional formative moment. Whereas in the Canadian context, if it's there in a root somehow, you can continue to grow and graft on new branches that might not have been contemplated by the framers through our theory of living tree constitutionalism. The problem arises, and I think this is really consistent with this morning's presentations, is when history becomes deterministic. Right, as if the turn to history is like the turn to God or Scripture or some unmediated force of authority, that if we just tell this right, if the priest can give us the proper read, that our problems will be solved. And so in the Canadian context, I think a problem with this is that originalism can entrench past discriminatory action. So if you're always trying to regard the past as a guide for the present, but you look to the past and you see Indigenous peoples were treated as inferior and therefore were regarded as lower on the scale of social organization, and you try to draw a present out of that past, there's the possibility that you continue to repurpose discrimination and just clean it up in some ways, but you leave the hierarchies in place. In other words, the purpose may be not discriminatory as you reformulate, but the effect still is the effect of the separation on the basis of hierarchies that are discriminatory. So you could have the Doctrine of Discovery or Terra Nullius read into law. In the Canadian context, you can only prove and secure a constitutional Aboriginal right if it was integral to your distinctive culture as an Aboriginal peoples prior to the arrival of Europeans. Those are the only rights that can be claimed constitutionally speaking. So it sends us in search of origin stories as Indigenous peoples. What was integral to us prior to the time that European came? How can we forward that, highlight that, make that a part of who we are when we tell our stories to the courts, so that they'll recognize that we have the ability to constrain government because of the constitutional protection that this attracts. You also find this, though, in the treaty context as well. We search for a common intention which best reconciles the interests of the parties. And again, we're going back to those either pre-contact or at the time of the signing of the agreement, understandings of genesis, right? Originalism also fosters ideas that words are objective, that they're certain, that they're determinative, that there's something we can find there, thus denying human agency in initial expression, formulation, and then subsequent expression and formulation, reception, or present interpretation. This is why Justice Scalia was so attracted to the theory of originalism, because he thought that got the judges out of the way. They weren't making law. Right? They were only telling us what was said once upon a time. The judge has no agency in this, just channeling. Interesting, right? Or at a seance, channeling another force that you are just passive as it goes through you to give the answers to questions. And again, of course, this hides or diminishes or it banishes other interpretive choices because of the passivity that it makes it appear to be, so that we end up with this idea that law is neutral, it's objective, it is the subject of another kind of will that's not a human will that could be interrogated. Of course, I've been looking at different kinds of originalism, and we have to acknowledge that Indigenous peoples participate in originalism on their own terms, in good and bad ways, just like in these other stories. Here are some ways that this occurs. Jacinta talked about this. Kirsty's research, when she was doing her doctorate and published her book, talks about some of this. The idea of blood is cemented in too many communities. If you can show that you've got a link to a drop of blood somewhere prior to the arrival of Europeans, that gives you an authority to be able to do something in a present situation as a result. And then family, elders, language, ceremony, lifestyle, skin, either the way we mark ourselves or the color of our skin can get implicated in these searches for originalism. Now, let me be clear, this can also be done on other bases. There's other ways of constructing marking of skin, lifestyle, ceremony, language, etc. But this is the comparative turn I'm trying to make here in the law as metaphysics mode. So we might say, well, we need to just get rid of originalism, or at least put history in its place, as Bain was saying, and make sure that it only tells us strange stories about the past and our present, and not be so deferential or worshipful of it. And therefore, we can turn to positivism, right? We can just let the legislature, through its collection, express our relationships, or have rights do that. Is that a way out of law's theology, is my question. With positivism, perhaps, it's a crowdsourcing technology. It allows for a kind of mob rule that doesn't put the metaphysics in the hands of an ultimate authority. It puts it in the hands, again, of us in the way we're living today. But there's Aaron and the golden calf. Moses goes up the mountains to get the commandments. What happens? Moses comes down the mountain. There's Aaron trying to build a god with the people and construct something of their own. But this clash of the originalism and the golden calf is the clash that you often see between treaty interpretation that's originalist and positivistic possibilities. You also, in the evolutionary moment, so if you take that, a more secular, if you will, Genesis story, but nevertheless with a metaphysics associated with it, has this idea of survival of the fittest, size matters. If you can get the constituency, if you can put the proportional representation together in such a way that you can claim authority, and that point you can speak and participate and replicate this kind of metaphysics. So there's challenges there on that front. Maybe it's the way out, but it's not necessarily the way out. Some people look to rights. Well, if we can't deal with the past because it's indeterminative, and it's subject to corruptibility because of its discrimination, maybe there's a universal language, a foundational place to start, something that has a beginning point as rights. And I've often thought, though, that rights themselves can stand in for a metaphysics in the way that God often stood in place as a metaphysical giver of authority. I took Exodus chapter 20. And rights spake all these words, saying, I am thy rights, thy a priori form, which has brought thee out of the pre-societal state of nature, out of the house of bondage. Thou shalt have no other a priori forms before me. Thou shalt not make unto thee any other preeminent a priori form, or any likeness of any other a priori form that is in heaven above, or that is in the earth beneath, or that is in the water under the earth. Thou shalt not bow thyself to them, nor serve them, for I, rights, am a jealous form, visiting the iniquity of the fathers upon the children unto the third and fourth generation of them that hate me, and shewing mercy unto the thousands of them that love me and keep my principles. That's the promise of rights. Thou shalt not take thy rights in vain, for thy a priori will not hold him guiltless that taketh his name in vain. To critique rights is to take rights in vain when people are suffering in the world, and there's this search for universal foundations which will solve our problems if we are just able to import a metaphysics that flows from a rights context. So there's challenges that you can see in there. So we might question then whether or not rights can be our savior. And I have a colleague, Ben Berger, who teaches at Osgoode Law School, and I was talking with him about this, and he came up with this little refrain, a Jewish man. Our rights, which art in charters, hallowed be thy claims. Thy kingdom come, thy will be done, on earth as it is in theory. The point, right, is that there's a metaphysics that not only flows from historical originalism that might be a part of positivism, but it's also a part of rights. And if we think that we can avoid this and are somehow postmodern, post-religious because of what we participate in, we have reason to second guess that. There are isms. I have to ask myself this question. As a lawyer, as an academic, am I sectarian? Right? Do I see everything as being in the common law world? Is that my sect? Is that my religion? Am I Catholic in that way of viewing things? Or am I ecumenical? Right? Yeah, there's a first law and a second law, but we've got a third law now, and they can be joined together somehow. And it doesn't mean I have to give up my sectarianism, but we can live together by just joining across traditions, not faith traditions, but joining across legal traditions to try to frame out what our relationships would be on that front. Or am I agnostic? I really just don't know. But I put another word beside this, which is from my colleagues Jim Tully and Jeremy Weber, who talk about agonistic, right? That law is formed through disagreement and continual deep dispersion and diffusion of authority, as opposed to being built through consent or fusion of horizons. In some sense, as a lawyer, I might be agnostic, agonistic, not sectarian, not ecumenical. As a society, how do we fall along that vein? What are the teleological or theological consequences of law that might flow when we start to examine the world in this way? In other words, do we have a choice, or are we commanded by our metaphysics, be it God, be it common law, tikanga, the way the common law itself works? Can we avoid replicating religion's authority in the law? That is, can we be idle, or is law an idol, God-like in its way? When I was growing up, I loved rock music. I still do. The Canadian rock band Rush. There's a song called Free Will. If you choose not to decide, you still have made a choice. Right? In some ways, we all have to come down and answer this question. Even if we don't answer it explicitly to ourselves, implicitly, we will be following a metaphysics that requires some interrogation. Can we own our metaphysics? Or to do so, would that out God, or would make God human? Or would that out the law? That the law itself would become less authoritative if it came up behind its curtain and we saw our fundamentalisms. And I'm not just talking about religion now. The fundamentalism of Anishinaabe law. The fundamentalism of the common law. Do we have fundamentalists in our country, in our profession? Am I one of them? What does that mean if that's the case? Or can we interrogate what it might mean in our roles to be, or our practices to conceive of law as a product of human agency, to recognize law as religion and politics? Can we recognize that we are not innocent? And this is the story of the Bible again, right? He takes of the fruit of the tree of knowledge of good and evil, and he doesn't want to face that fact. So God speaks to him when he said, I hid myself in the garden because I was naked. And that might be an option that we take, is trying to hide from the fact that this agency is in ourselves. Or this Sky Father, I've got that back, no, Sky Mother, Earth Father, got it backwards there. But how do we live in the light there, right? When things have been pulled apart and then we have to interact on this realm, can we recognize our agency there? So to return to and end where I began, beware the danger of a single story. In legal circles, we think we are modern, we think we are postmodern, but patterns of thought and practice, I think, continue to replicate metaphysics. And there's some reason for us to own that, to not deny it, not to try to hide behind it, and replicate other troubling systems of authority as a result of that fact. Miigwech bizindwi igmi'u ahau. Thank you.
Well, thank you, John. You could have maybe stayed on the podium there. Thank you for a, I don't know, it's a very different talk. I'm still, it was good, but it was very different. Does anyone want to make any comments now? We do have some moments for questions, and I know that both David and Ned may be kind of continuing on in this conversation, but we do have a moment to pause here if anyone has a question or a comment. Yes, Bing?
Thanks, John. That was wonderful. I guess at least some of what you were saying reminded me of Benedict Anderson's famous argument about histories as imagined communities. But also part of what Benedict Anderson says that I think people tend to forget is that when he talked about national communities, he said they were emotional communities. and it seems to me, and I made sort of an aside to this in what I was saying, that the power of mythic stories, and partly their power is because people have a connection with those stories, which is an emotional connection, and that for academic historians like myself at least, if we don't recognise the power of mythic stories and think somehow that our secular stories, which might not be especially emotional, are going to somehow do the work of an origin myth or something. I mean, we're deluded if we think that they can do that, because I think there's lots of evidence that what people connect to are mythic stories, and partly because they have the kind of aspects that I think you're talking about in a somewhat different way.
Yes, I mean, we don't reason without emotion. Our emotion is always engaged when we're reasoning. It helps us to calibrate, make judgment, put feelings on one set of factors that you've calculated and weigh them and balance them against another set of factors that you might have calculated. And so emotion is very much present in the way we operate in our present terms. It looks like it's banished because of the kinds of ceremonies that we have when we convene court, or the way we often read legislation in cases in law school. But make no mistake, there's not only an emotion present in the way that it's generated, but there's quite a strong emotional attachment in our countries, Canada, New Zealand, Australia, United States, as we engage in this process of common law metaphysics. People are true believers in that, right? It's not necessarily calculated, but there's the emotion of the belief feeling that if we were to depart from that, would be apostasy, or would have us depart the faith of our ancestors and the good that might have created for us.
So that was fascinating, thank you. My question is about the concept you raised of fundamentalism.
Yes.
My understanding is that some religious fundamentalists believe themselves to be part of a democratizing movement, so that by having recourse to fundamental values, you take the task of interpretation out of the hands of an elite and put it back into the hands of the people. Mm-hmm. Does that fit in with, does that have a strand in the story that you've told us today? I was listening for it, but I'm not sure
I don't think I have developed that quite as strongly as I could, because my concern about fundamentalism is when foundations are created that are kind of off limits for our continued interrogation, interpretation, interaction with. And the story of fundamentalism that you're describing is to try to allow for people to be involved in the development, interpretation, interaction with the law. So I'd be interested in literature or source guidance that you could give me on that point.
Historians and lawyers do have origin stories. We deal with them. But I'm casting my mind, and I'm doing a work at the moment on the history of my university, and I'm particularly interested in the 1960s. And things like the new brutalism in architecture, that many of us live in new brutalist buildings that were created in the 1960s. And certainly as an undergraduate student and in social sciences in the 1970s, there was a real sense that those people who were interested in origins were themselves antiquated. I mean, it's structural functionalism. It's a sort of emphasis in both the New Left in a complete rejection of stories of origin. And if you look also, I think, at Māori, pan-Māori nationalist movements, solidarity of colour as it emerges in the 1970s, it's far less interested in history than it becomes when it attaches to tribal histories. And my question is, have we, in a sense, become more connected in the disciplines that we have with originalism? And maybe that was one of the weaknesses of that supposed secular presentist revolution that didn't happen in the 70s.
That's very interesting, Michael, you're saying that. I put this slightly different, is that you know in the discipline of history that for a long time, narrative history falls away, and it coincides with the rise of history as a social science and a focus on analysis. And then there's a return to narrative, because it seems to me another way of putting what we're talking about is the importance and the power of narrative as a device for persuading people. I mean, partly it's because narrative, as we all know, is a cognitive instrument. I would argue that if one can generalize across cultures, narrative is common to all, partly because it performs the function of that's the way we most come to understand. That's the way we create understanding. I think too, and the legal scholars will know this better, isn't there a book by Jerome Bruner and Anthony Amsterdam about the importance of narrative in the law? I mean, Jerome Bruner, some of you might know, is a cognitive psychologist, but he's written in really interesting ways about narrative. But then there's this book that he does with, I think it's Anthony Amsterdam, about the importance of narrative in the law. And I think they use various American examples, including civil rights examples, to show just how important narrative is in persuading people of certain positions.
Yes, and so narrative is obviously a part of the continuity I've shown between the metaphysics of religion and law, but then we have to remember that both in religion and law, it has impacts on physical bodies. So, legislation gets enacted, people are excommunicated or put in prison, whatever it happens to be, which is my point, and now I'll sit down. It's why I've always been attracted to trickster stories. My own scholarship has talked a lot about Nana Bojo or Nana Bush, our trickster, because it becomes a way of problematizing the neutrality, the timelessness, the hands-off nature of things, because the trickster seems to always come in there and turn aspects of that world upside down and shows that it's possible to interact with it and have some change occur as a result of that interaction.
Thank you, John.